Hi, and welcome to the ESI Africa Live webinar. I'm Nicolette Pomba-Sansel, editor of ESI Africa, and your moderator for today's discussion, exploring the power project procurement, planning, and execution landscape. This topic has grown in interest as the deployment of renewable energy projects gathers momentum, especially in the African continent. However, procurement processes require a combination of design and implementation to achieve low prices and high project realization rates. To discuss these elements today are three guest speakers who come from dynamic backgrounds with a vast array of procurement, government, regulation, energy backgrounds, and expertise under their belt. Each of our guests has actively participated in Power Africa's latest Understanding Series Handbook on Power Procurement Planning. They are Jay Govender, Mohammed Badusi, Lina Mangondo. And for those who have just joined us, welcome. To the listeners, on the left-hand side of the screen, you will find the Q&A box for you to use throughout the duration of this webcast. Your questions will be considered for a live response. Also look out for our survey questions that we will pose to you during the course of the discussion. So with no further ado, I would like to ask our panelists to introduce themselves and their involvement in the Power Planning Procurement Handbook. Jay, you're first up, to please introduce yourself.
Hi, good afternoon. I'm Jay Govender. I work at a law firm called Hofmeyr, and I'm a practicing attorney. I'm also the national practice head of the Projects and Infrastructure Department, and I specialize essentially in infrastructure and energy projects. I advise across a portfolio of projects, both in South Africa as well as in Africa, and represent various clients from off-takers, developers, financiers, sponsors, essentially anyone along the energy value chain. I was fortunate in being able to be involved as a co-author in the latest handbook called Understanding Power Project Procurement. And I was also involved in the previous two Understanding handbooks. Thank you.
So much, Jay. Mohammed, what was your involvement in the handbook? And please introduce yourself to the audience.
Oh, sure. Thank you very much. And good morning to everybody from Washington, D.C. So I am the senior attorney for energy and finance at the U.S. Department of Commerce. And essentially my role is to support foreign governments in their procurement and their planning and their even legal reform around facilitation of investment in power projects. So everything from contracts to financing to procurement procedures. And we work with dozens of governments around the world. When it comes to the handbooks, it's interesting, as Jay mentioned, this is the third in a series of handbooks, and this project started in 2014. Originally, the plan was to write a contract, the perfect contract, the contract that everybody would love and everybody would use for power projects in the African market. And we gathered, a group of internationally renowned experts in a room to talk about that. And within 5 minutes, we realized that writing a contract was an absurd exercise. So instead, what we settled on was the drafting of the first handbook on power purchase agreements to describe what a good contract would look like, then a second handbook to describe what financing structures look like, and finally this third one on describing the ideal, or at least the most successful procurement procedures. So overall, I would say that the philosophy behind this handbook series has been reflecting the knowledge in today's market from multiple perspectives, from governments, from private sector, from banks, from law firms, etc. And it continues to be an ongoing project. We've revised the handbooks. We're constantly updating them for them to be as current and as representative as possible of the best practices in today's market.
Thank you, Mohammed. So these are living documents. Lina, would you please introduce yourself as well as your involvement in the handbook?
Good afternoon. My name is Lina Mangondo. I am head of legal at the IPP office in South Africa. And based on my experience over the last 6 years in the South African ICP procurement program, I was then asked to form part of the team that developed the Understanding Power Projects procurement. And essentially, within the ICT office and my role more specifically, I am looking at not just legal and regulatory issues, but also looking at ensuring that ultimately when the procurement documents do go out to market, it is something that from the private sector's perspective, they will find acceptance, as well as various other key stakeholders from the private sector who then support these projects. That knowledge and experience was also a part of my contribution to the handbook.
Oh, that is quite a bit of involvement. Thank you, Lina. And we have the experts ready to answer your questions. So please start preparing questions and putting them into the chat box. Mohammed, I have a question for you, which is around the importance of regulation and policy. So how important is regulation and policy in a country to procurement planning? And from your experience, and you have vast experience here, what aspects are seen to create a less conducive market for procurement planning?
Well, it's a good question, and I think it's a good question to start with. I think at the outset, it's important to point out what we mean, by procurement and what the distinction is here. That in our work and in our definition, procurement is the active promotion, the active structuring led by governments of developing a project, whether it be for power, or any other sector. The difference is that the traditional model has been an open door policy where governments simply keep their doors open and companies come and propose projects. And the reason that laws and regulation and procedures are so important in the procurement process is that if the government is to lead the process, it must lead it through a defined manner, a predictable manner. So the governments that we've seen be most successful in the procurement space are the ones that have done extensive planning, extensive consultation, everything from technical reviews to legal reviews. And that often that process is defined in the law or defined in the procedure. It's not simply created in an ad hoc manner. One thing to point out about the importance of laws and regulation is that sometimes the most difficult part of the procurement planning process occurs within the government, because oftentimes procurement involves a bit of a sacrifice of the traditional discretion that governments have. So as opposed to a procurement agency, the Ministry of Power, figuring out what it wants as it goes along in a negotiation, or even a tax authority figuring out the treatment of a particular contract structure as it goes along. All of those structures, all of those treatments, all of those definitions of the project have to be agreed upon ahead of time before the project going to market. And that involves a lot of consultation within the government. It involves a lot of, we say in English, horse trading, a lot of consensus building, but also a bit of sacrifice of discretion. And we've often seen that the governments that are most successful at the end of the procurement process are the ones that took the most time at the outset to basically consult amongst agencies and formulate a solid and agreed upon procurement policy, within the government before they go to market. And just one last thing to point out, I think maybe if you were to look around, the governments that have conducted procurements recently, especially in the African market, but this applies in other markets as well, that act of developing the procurement, that act of setting the procurement procedure, of sacrificing a bit of discretion, it's a very difficult political decision. And the governments that have managed it the most successfully are the ones that have handed that authority, have handed the procurement authority to a relatively independent agency. And, we're lucky to have, Lina on the phone call today. I think the IPP office is a wonderful example of that, but we've seen it in other markets as well, as where if governments are serious about a defined, predictable procurement process, they need to remove it from the political space and have that process driven by a specialized, professionally managed agency that is really going to focus on the projects and not on the politics.
Thank you for sharing that with us, Mohammed. It seems like it's a very intricate process to go through, and as you say, if the government is serious about getting to that point, they will definitely reach that. So, Lina, then let's talk about some of the prerequisites and what are the key prerequisites to proceed with procurement processes. You know, what is it that needs to be in place before we even begin and then at the initial stages?
I would just like to follow on what Mohammed said. It's absolutely necessary that as government you have pre-planning, ensure that you have identified the competencies that you need in order for you to undertake any procurement process. Because I think as government, sometimes we are of the view that the private sector is just out there to make a profit at whatever cost. But ultimately, when any private sector party looks at an opportunity, that's not the only opportunity. There are other competing opportunities. So when they look at the opportunity and the conditions that apply to such opportunities versus other opportunities they can get in the market, they have to weigh up whether it's to ultimately meet their investment requirements as well as the likelihood of success. If they don't, if as a private sector participant they see that it is aligned with their interest, or ultimately there's a great degree of success for them, they will just look at other opportunities, or they will just participate. They will just participate for the sake of participating without necessarily taking the opportunity seriously. In this respect, it is necessary that the right competencies are in place to enable quick decision making, as this provides certainty and confidence to potential investors. Typically, if there is no clarity provided by the procurer or government, this results in delays or cost escalation. And from an investor's perspective, they will just price in a premium for the level of uncertainty that is such lack of planning or lack of clarity on the part of government. Also, it's important to, when planning for procurement and in your procurement process, be clear, having regard to the actual demand for electricity, that whatever you are procuring will ultimately be able to meet the demand, and that the type of power that's being procured will be able to meet the demand. Obviously, you don't want to over-procure, as ultimately you as government and from the perspective of the private sector, you sit with a situation where you've got surplus capacity, which you may or may not be able to sell elsewhere, as well as affordability. That is a key consideration, and one that also drives what and how you procure, as ultimately the ability of the investor to recoup their cost and make a return on investment is a key consideration for them. In the procurement process and as well as in planning for procurement, it is important to have a package in place to ensure that whoever the off-taker is able and willing to meet their ongoing financial commitments under the power purchase agreement that is ultimately concluded arising from whatever the choice of procurement is that government ultimately embarks on. And to the extent that, as we've seen in a number of jurisdictions, particularly in a number of developing or least developed countries, you have a situation where there's a lot of revenue leakage. You have utilities that are not creditworthy. and in this respect from government, they have to look at what sort of credit enhancement instruments need to be in place that the off-take commitments under the power purchase agreement will be catered for ultimately. It's important to ensure that the interests of all stakeholders are taken care of, and this presumably could be ensured by having engagement with key stakeholders prior to and even during the process of procurement, as you're able to take on board their concerns to ensure that ultimately whatever you have in your procurement process or in your procurement documents will provide sufficient comfort to whoever you're targeting to ultimately invest. The mandate of the procurer, it's important to ensure that the procurer has and confirms during the procurement process that they have the relevant mandate. As you don't want to embark on a process and later find that actually the mandate wasn't there, or there's something that there was a consent required prior to embarking on procurement, which then derails or potentially delays the procurement process. And in this respect, from whoever is doing the procurement, they need to also ensure that they have the necessary skills, capacity, and experience. And for instance, Mohammed alluded to the IPP office. So with the IPP office, and I'm going off on a tangent, we recognize as government that there are officials within government who are tasked to ensure that ultimately, from a security of supply perspective, there was sufficient generation capacity. But those government officials have their day job. The procurement to ensure that you had additional generation capacity was something that they needed to fit into their day job. The best way to achieve that from government, it was recognized, was to ensure that there's a dedicated team that would only manage and undertake the procurement processes. And ultimately, from a government perspective, that should be a key consideration. Do you have the necessary capacity to ensure that you can run and manage a procurement process, or it's best to make sure that there's a dedicated team that ultimately manages that procurement process? And even within that team, they may have expertise in certain areas that do not necessarily have expertise in all areas required for a procurement process. So where those expertise do not reside within the dedicated team, it is advisable to go out into the market to try and augment the capacity that are within that dedicated team. And
Thank you so much, Lina. You have pointed out quite a bit that needs to be in place to ensure that the procurement process really goes smoothly. And I like the fact that you do mention that certain expertise is necessary. I'd like to then move on to a question for Jay. And from your experience, Jay, can you provide some reasons why projects are sometimes delayed, which as a consequence does put developers on hold? And how do you keep that market then alive with this delay in place?
Thank you for that. So I trust that you have to save the question for providing reasons for delay to the lawyer. But anyway, I'll attempt to answer this one. So power projects, and we are talking about power here and procurement in the power context. So power projects, no matter what their size is, whether it's 5 megawatts or 100 megawatt project, these are very complex projects to develop. And I think that there are many facets that make up the development of a power project, and there could really be delays in any of these components. So typical delays could be caused through maybe key project risks not being identified, or project risks actually materializing, those that were identified actually materializing. And delays could be either in the procurement phase or in the development phase. But since this session is focused on the procurement phase, from my experience, I'm going to try and touch on some of the reasons that I know from projects, not just in South Africa, but across the African continent, that were delayed for various reasons. And interestingly, I think there's quite a bit of overlap, because the stuff that Mohammed and Lina has just articulated, the points they've raised, is actually some of the key reasons why projects are in fact delayed on the African continent. So I think somewhere on the top of the list would be maybe lack of enabling policy, or if there is policy, inadequate laws and policy to support the particular project. And this just not only goes to the law pertaining to the structure of the electricity supply industry, so how it's made up, whether it's vertically integrated or unbundled, and how the different functions work. But this is also laws and policy on other important aspects that are key to a development of a power project. So energy planning, which both my colleagues have touched on already, just very clear procurement rules where there is government procured projects. Tariff setting and approval is actually key to the sustainability and also financial viability of any of these projects. So generally sound law and policy around that. The licensing regime and how that works, timing, approval, process. Cost recovery for the off-taker, where the off-taker is the utility or the government, is also key, because if you're purchasing energy of a particular PPA that's being procured through a government-regulated process, that off-taker would also want to ensure that it gets ultimate cost recovery on that tariff. And also laws on just foreign investment and how the project is treated, where there's foreign investors involved, where there's a difference in currency, etc. So lack of policy is one of the key reasons why I believe projects are delayed. The other could be poor procurement planning and documentation. And again, both Mohammed and Lina expressed a similar sentiment. So I often have clients who approach us, if it's government or utility or being the procurer itself, who actually, through various reasons, it could be political pressure, it could be a particular mandate, but there's essentially a rush to meet a deadline. And the approach is sometimes in those instances that, don't worry, we'll work it out as you go along. And this approach leaves a lot of discretion on the private sector or the project developer, which invariably does lead to scope creep. It may lead to higher tariffs, because if there's variations on scope, it immediately entitles the private sector to open up discussions on the tariff that's being bid in, if it was a bid-in process. And this in itself leads to delays in timing. The third point goes to the point that Lina also expressed. Again, sorry, there's a lot of repeat, but I think that we didn't exchange notes. So obviously, these are probably the key issues that each of us are also experiencing. Institutional capacity, so just lack of resources on the part of the procurer, or a lack of skill and expertise. And please don't get me wrong, because I'm not saying that government and utilities don't have energy expertise. But the reality across Africa is that historically our governments have been modeled, and utilities have been modeled in a particular way, and that is they are vertically integrated utilities. There's very few countries that have unbundled models. And this essentially means that historically these utilities undertook their own generation projects. And when you look at private sector involvement, it brings in a completely different complexity, a different risk allocation, and it calls for a different knowledge. So again, I'm pleased, with respect, I'm not saying government doesn't have the knowledge of energy. I am saying that there is generally a lack of resources in government to deal with those projects where private sector is involved and it's project financed, because it's not a model that the utilities are not accustomed to. And so this does create almost stalemates in decision making, or alternatively, as I said, delays. The fourth is cooperation from various government departments. I mean, I started off saying that the development of an energy project is pretty complex, and it involves various pieces of a puzzle that needs to be put together that ultimately culminates in a successful project. And from a government point of view, it also then means that there are various different departments of government that are involved in a single project. So the procurer could be different to the licensing authority, to the regulator and the tariff, to those that may give, an EIA approval, etc. And even if you have a particular department absolutely driven to get the project over the line, there could be delays on the other departments. And so this is an age-old debate. I mean, I recall saying this from early days of practice, that cooperation between the government departments, even if one has to consider an MOU that is especially driven to a particular project. And I think that was done in the South African context with the renewable program, and that's why that project has been successful, because there has been buy-in and cooperation from government departments. But we don't see this often in other parts of Africa. I think another point may be procuring entities not conducting proper due diligence on what is required for the development of a project and what that impact would be on timing. And, sometimes we find that risks are identified when the procurement process has already hit the market. And that is a little too late, because if you're a procuring entity, you ultimately want to provide this, you want to know for certain as to what it is that you want to achieve, and to provide certainty to the bidders, it's good to do your homework, and that would be in the form of a due diligence. Interestingly, we are seeing quite a few issues around resettlement that have surfaced in a number of jurisdictions over the last couple of years. And since compensation mechanisms are highly regulated in most jurisdictions when it comes to resettlement, these types of issues can cause delays. So that's just a few. I mean, this is a topic on its own, so I just thought I would touch on those that are more prevalent than the others. And I think your second question to me was, how do you keep that market alive in the face of a delay? So the obvious response is that you solve the issue, but obviously that's not as easy. I think that in the context where there is these sort of challenges and hurdles and difficulties, my view is that the way to keep the market alive is to have a transparent, open, honest communication with the potential investors. And I don't think investors ever expect a perfect project from day one or perfect procurement. But as the procuring entity, if you can demonstrate an understanding of the issue and give the confidence that it is being resolved, that in itself should give the market comfort to actually stay in the game and wait for the issue to resolve itself. And I think that it's silence on the part of procuring entities is what may kill a market.
It can definitely put a spanner in the works, so to speak. Thank you so much, Jay. I just want to bring to the audience's attention that we have a survey question coming to them. They should receive it any moment now, and you have only a few seconds to respond to it. But meanwhile, I'd like to pose a question to Lina, and this is around sharing your advice with companies that wish to participate in an auction or tender process, and what considerations should they have top of mind?
I would say that as a company wishing to participate in any procurement process, the key issue would be, what are the requirements? What do I need to demonstrate in order for me to firstly be able to meet any qualification criteria and to put forward the best bid to ensure that ultimately you meet the requirements of the procuring entity. And also pricing. It is a key consideration, particularly if, for instance, you're going through a competitive process. That will ultimately be what determines who gets the bid, who provides the best, who provides the best price and the best value for money to the procuring entity.
Right, thank you so much, Lina. We have so many questions, and Mohammed, here is one for you, and it's around what are the overlooked areas, often the detriment to the success of a procurement process, that you can advise the audience on as potential pitfalls?
Well, it's a good question because, we've had the luxury of working with so many governments that we have seen a number of pitfalls, a number of mistakes that are made. I would say the largest problem, the biggest mistake that most governments make is to treat the procurement planning process and treat the procurement, execution, the actual conducting of a tender, be it competitive or not, as a government-led action, as a traditional, political or traditional policy exercise. The reality is that when a government is conducting a procurement, it's taking off its government decision-making hat and it's putting on a business hat. It's starting to think like a project developer, and the best procurements are those that anticipate the concerns of the market. Jay mentioned things like resettlement. It could be, tax issues. It could be even customs issues. The best procurements are the ones that anticipate those issues, address those issues ahead of time, settle the concerns of the market, and therefore the bidders that come in will bid lower prices because they see lower risk. So one of the mistakes that most governments make is they make these decisions behind closed doors. We use the term openness in a lot of our work. Traditionally, government decision-making is done behind the wall. It's done through internal, consultation. And I couldn't put it more simply than this. If you want to know what the market wants as a government, then ask the market. The biggest mistake most governments make is a lack of interaction with the government directly. They often have to, do their own studies, they do their own evaluation, and they never share that information with the public. I think the IPP office we've mentioned in South Africa, we've seen this even, recently in places like Senegal and Kenya, is the more the government communicates with the market, perhaps you publish an initial assessment of what the power need would be, and then you have public consultation. You then publish an assessment of what the sources and the volume of power that are needed, which technology you want, and have public consultation. We've even seen governments publish the contracts, publish the procurement documents ahead of time so that the market can comment on whether or not they actually address the risks that they're trying to address. I would summarize it this way, is that the more communication you have with the market, and they are happy to have that communication with you, they're a partner in this process, the more likely it is that you'll actually hit that target of designing a procurement that is competitive, that is, that's popular and actually invites the participation you want. One last thing to mention is that the governments that we worked with that are the smartest about this realize that the best procurement is the most boring procurement. What does that mean? governments sometimes make the mistake of trying to innovate in the wrong places. In the energy space, innovation should be focused on the technology, better solar panels, better energy efficiency. And frankly, your legal, your financial, your procurement procedures should be the most boring part of the entire project development. You want to adopt procurement procedures that are well known, contracts that are well known, financing structures that are well known. There's a danger sometimes of overthinking by government, of trying to push new contracts, new terms into the market, when in reality you want to adopt the most well-tested, well-used, well-understood procedures, because again, that comfort of seeing a contract that's familiar will translate into lower prices from the companies that come to bid or come to propose a project. So I would say two mistakes that often are made is a failure to be open to the market, to interact with the market, and over-structuring, over-engineering, over-innovating in the procurement space, when in reality you want it to be a very straightforward and following your peers in other markets as opposed to being a standout.
Yes, thank you, Mohammed. As you say, a boring process is really our most secure one. Jay, we have a question for you around the various competitive and non-competitive procurement options, each with their own set of pros and cons. And in your view, which of these can be considered for the unique conditions in the African market and why?
Okay, thank you. When we considered the book, and Mohammed usually leads the team that authors the book, but always being brought to the table with very ambitious targets. But when we considered this book, we did give some thought on the first day as to whether we could write a handbook on the best practice approach to procurement in Africa and find that optimal procurement solution and perhaps write about it. And our deliberations actually led to us agreeing that it was not possible. And it was not possible simply because the procurement option that one chooses for a particular project is very much driven by what the objectives are behind that procurement process. And I'll come to objectives in a second, but I think you asked about the options in competitive and non-competitive areas, and maybe we can just talk about that for a short while. So there's also some confusion about what competitive processes are and what non-competitive is and what is unsolicited type of procurement. And the way we approached it in the book is that we essentially categorize the procurement options into two. The first being competitive, and competitive can be achieved through various mechanisms. So it could be regulated through policy or law, or you get parties who run a competitive process of some form or the other. And this could even be private sector, because many of our private sector clients who, even though not regulated by any policy or law, still opt to go to market through a competitive process. And then you get the second category, which we term direct negotiations. And direct negotiations could either be unsolicited, where the private party approaches government or the off-taker and says, I have a project for you and would you like to engage with me? And that's how a deal could be struck. Or you could get direct negotiations where the government initiates the discussions. And this could be in the context of that particular jurisdiction not having regulation or being in a development stage, or simply that the government has opted that that's the way it's going to procure a particular energy project, and in that context there are no legislative restrictions to the government behaving in that way. So under the context of those are the options available, I think the short answer to your question is that there is no one solution or one option that would fit a particular jurisdiction. And then going back to what I said initially is that our conclusion when we were sitting together deliberating on the book is that one has to look at the objectives in order to determine what would be the optimal procurement process in the situation. So let me give you some examples. If, for example, your objective is that you need to achieve security of supply. So we are, in this example, in a jurisdiction where demand growth is escalating and there could be some need to fast-track procurement. In those instances, governments would opt to go the competitive process, or they could go the direct negotiation process, because the objective there is to get supply as soon as possible and in a secure manner. You could have another example of emergency power. So the objective is to get emergency power, you need something tomorrow. In those instances, the procurement option could be that you opt to have a deviation. You opt to create an exception to all of your procurement processes and actually go to a single supplier or whatever. It depends what your particular law in the country allows. But it could be an option of following no process at all. If the objective is you want to achieve the cheapest tariff, so you have the demand, timing is important but not that important, but you want to get the cheapest tariff, then I think that in that instance, you may opt to go the most highly competitive, regulated way you can and do a lot of advanced preparation, de-risk those projects as much as possible, and try to go to market in order to achieve the cheapest tariff. In this example, you could also opt for the way South Africa decided, which is procuring by way of a program as opposed to on a project-by-project basis in order to achieve competitive tariffs. And procuring in a program could also aim to achieve scale if that is your objective. And what we're seeing increasingly, and I think that South Africa has definitely been the model and the precedent for this, is that we are now seeing in almost all jurisdictions who decide to go regulated procurement that localization objectives are included in the procurement process. So it's no longer just about tariff and security of supply and technology and all of those good things that generally make up a conventional energy project, but it's also about who is involved in this project at a local level, what is the benefit to the country, what's the job opportunities, manufacturing opportunities, local participation in projects. So, I think that's it in a nutshell. There is no one solution, but I think one has to really carefully consider what it is that you want to achieve and what the optimal process is in order to get there.
Exactly. Thank you so much, Jay. I think we should also just remember what Lina had said about we don't want to over-procure as well. So we want to find a model that works for you, but you also want to make sure that what you're procuring is something that your demand is going to be able to take up. I have another question for Lina right now, and this is a question around as a developer, what should be expected as part of the bid package when a government or national utility announces intention to competitively procure power, for instance, using wind or solar?
Thank you. Obviously, it depends on the procurement approach. Is it open tender or is it restricted tender? Both of which are variations of an open competitive procurement process. And you'll find that in the handbook, we've set out a number of steps in a procurement process. So again, it's dependent on which approach government takes. But But what is clear is that whether you decide to first go out to the market to test the market appetite and capabilities, or go and thereafter then go through an RFQ, request for pre-qualification and request for proposal process. Ultimately, all of those stages are to test market capabilities, which are set out in a various set of technical criteria, which basically require potential participants or bidders to demonstrate knowledge, experience, and skills related to the particular technology type, as well as testing to the extent that the particular project participants have got different roles in the project. There's specific expertise and experience associated with the role that they will be playing in that project. You then have on windmill solar, typically it's around has a project developer developed or built and operated either a wind farm or solar project, and in that respect, it can either be in the operation of such solar farms or the wind farms, or demonstrated capabilities around the specific construction or EPC elements of each associated with each of the technologies, as well as a demonstrable track record with references. Also, where you then are looking at the specific technology, whether wind or solar, one would look at what is the technology, what certification does that technology come with, where you, for instance, select your own project site, as we have required in South Africa. It would be around the resource data associated with the specific technology. For instance, with solar, you would look at the solar irradiation for the particular site that's been selected, and then with the wind, the wind resource and the reliability of the wind resource at various heights. That would then say, from a government perspective, is the resource data that's provided sufficient to be able to generate either from wind or solar to achieve the energy generation output that's expected from a particular project associated with the particular resource. Another consideration would be what support, either from technology providers, come with the specific technology, what guarantees, what warranties, and technical support they provide for the particular project components, as well as the financing package that is associated with the particular project. And obviously, then would be once a project component has demonstrated the technical criteria, to the extent that it is an RFP process, to then say, from a pricing perspective, what is the tariff that is then proposed, and relative to other participants, where does the offering from a pricing perspective then sit from a ranking perspective?
Thank you so much, Lina. I think that's a question that a lot of the audience members and readers of the handbook want answered. I just want to remind the audience that they can keep their questions coming in. Even though we are almost at the end of the webinar, we can always pose these questions to our guest speakers later. Mohammed, I have another question for you, and this is from a listener who says that they have projects in Ghana and other countries as well, which are supported by USAID, but haven't seen any in Nigeria. The question is, has there been any, or is government not supportive?
It's a good question. This is a question we face, frankly, from almost every government that we work with, not just in the African market, but around the world, which is, where are the results? Where are the outcomes? The most direct answer I can provide is that Nigeria is actually one of the largest portfolios of support from the U.S. government, not just from USAID, but also from my agency, the U.S. Department of Commerce, from the State Department. We have dozens and dozens of personnel on the ground actively supporting the government, and everything from large power projects like the Azura project that closed last year to the use of off-grid power with the more than 10,000 proposed off-grids by the Rural Electrification Authority. One thing I would mention that with Nigeria, and this is something to keep in mind with procurement in every market, we've said time and time again that procurement is a process. It is a process that's meant to be predictable, it's meant to be orderly, and that process is government-led. And so as much as a developer may be eager to move a project forward, or we may be eager to support a government, it is ultimately up to the governments themselves to design and lead that process. And I will say that although you may not see movement, you may not see results in the short term, the processes that are well planned, well executed, take time. I mean, Lina, I don't know if we mentioned this already, but it was a multi-year planning process for what is now, highly regulated renewable energy procurement in South Africa. These things are not fast. The entire idea behind the procurement is that you do a lot of the work up front, the design, the planning, the structuring, so that you have the better results afterwards. So to anybody in the audience who seems frustrated, who hasn't seen results right away, part of that is typical government delay, which you see in my own government as well, but part of it is the nature of procurement being a long-term and orderly planning process that does take a considerable amount of time.
That's a very good point to make. And I'd like to pose a question to two of you, to Jay and Mohammed. I think the next question has a lot of various responses that can come through here. And the question is, there appears to be debate regarding how financial close ready projects need to be at the bidding stage. Jay, if you can share your thoughts on that first.
Yes, I think that we mentioned earlier that it's important to strike a balance between achieving an optimal procurement process and also not over-procuring. And this is actually a very relevant debate, especially from the perspective of our private sector clients. So development costs in order to have a bid that is essentially, ready to reach financial close is very, very high. So development costs are exceptionally high. It's high cost to submit a bid, and it's also high cost to obtain all of the approvals, etc., negotiate contracts, agreements in order to reach a stage where you're almost ready to reach financial close. And a lot of the criticism from our private sector clients is that it's unreasonable to expect them to incur such high costs when there isn't certainty that they are going to win the bid. And the way South Africa has decided to manage the process is to have bidding entities and then almost appointing a preferred bidder where you would know that you are, so long as you reach financial close, you're certainly going to get an agreement signed within the context of the process. In other jurisdictions, that's not necessarily the case. And I've had an example where we acted for a client and there were 66 bids that had to come in on a single project. And one then has to question about how much of development costs of the private sector reasonably expected to put into that project when it's a 1 in 66 chance of winning? And so I do think that there needs to be consideration about having bids as ready as possible for government to get to where they need to be in their project, but also careful consideration as to private sector and the costs that go into bidding and development and the expectation about really having a sophisticated bid response. Thank you.
Right, Mohammed, do you have a similar response to that?
Yeah, I mean, I would just add two observations that we've had on this question of financing already. I think that, sometimes this question about financing comes from the traditional thinking of government, where when the utilities used to develop their own projects that were state-led, they would rely on state financing. That was very straightforward. When they used to have an open door policy where where companies would bring projects to the government, there was an expectation that the project would come with financing behind it. So again, the government had a very simple approach there. The challenge with procurement is that because the procurement process is government-led, the government is also in the first position to set forward the terms that make financing possible. And that's a very new position for governments. We talked before about openness. One of the most important forms of consultation that a government can take ahead of time prior to conducting the procurement is talking to the banks, talking to the financial institutions, and anticipating in the procurement process itself what the preconditions would be to make the projects financeable, to make them, financial close ready, I think as the question said, at the end of the day. So governments can no longer rely on the developers to be in the first chair and to be in the first position for arranging financing. Governments have to actively anticipate and put in place the conditions for financing as part of the procurement. And it's a very new exercise. And I think Lina mentioned this before, when it comes to competency, it's not a natural competency for governments to have, and sometimes it's a place where you may hire an outside advisor or consultants that help you anticipate and structure those financial issues. The second thing I would mention, and Jay hinted at this, but it's worth saying again, if you place too much burden on the developers, you want them not just to have the technical proposal, but you want them to have the financing arranged, you want them to have all these other aspects arranged ahead of time, you are constraining the amount of participation in the procurement. I mean, the greatest innovation in today's energy market is the ability of small, innovative, well-run developers to put in place, wind, solar, biomass, other projects. And if you're placing more cost, then you're squeezing out these low-margin developers. So the cheaper you make the ability to bid into the procurement process, the more competition you have, and ultimately, the better prices and the more innovation. One thing to point out is we've seen some governments, Argentina comes to mind, but Uganda did this as well, have actually gone so far as to pre-arrange some of the financing as part of the procurement. In Argentina, the government arranged financing for solar projects ahead of time. In Uganda, the government arranged a partial risk guarantee with the World Bank to de-risk the project ahead of time. And what's fascinating in both cases is that work by the government to pre-arrange the financing was never utilized by the developers. Not a single Argentinian bid winner used the government financing. Not a single winner in the Uganda Get Fit project used the partial risk guarantee. But the act of structuring that financing brought more lenders to the table, reduced the cost of lending, and made both of those procurements ultimately more successful. So it even may have an indirect effect sometimes. When governments are smart about anticipating financing needs and putting in place the conditions for financing, you will find that they actually create a scenario where there's more competition even in the financing space, and ultimately a lower cost of capital and a lower cost of power.
Right, and that is bringing us into the close of our discussion, which has been incredibly interesting. And I know that Power Africa is still going to continue doing incredible work on the continent and with regards to renewable energy. I want to thank our guests for their time and sharing their expertise. And also to our audience, to please look out for the survey questions, which will be coming to you post-event. And I just want to also remind you that a recorded version of today's discussion will be available for you to access on demand, along with a hyperlink to the digital version of Understanding Power Project Procurement Handbook. And I think it's a very worthwhile read. Thank you all for tuning in.